All right, good morning, everyone. I would like to call the recommending committee meeting to order, October 14th, 2019 at 10 a.m. Item number 2 is we are in compliance with the open meeting law, correct? Thank you, we are. Item number 3, this is bill number 2019-31, it's abeyance item for possible action, amends various provisions of the Unified Development Code in Title 19 to provide clarification and standardization relating to distance separation standards and measurements, clarify when access-related standards refer to vehicle access or pedestrian access or both, and establishes additional standards regarding the interpretation of terms. Mr. Lowenstein.
Thank you, Chairman. This item, as described, is clarification regarding public access to determine throughout the entire code to clarify when access is vehicle, pedestrian, or both, as well as it seeks to establish a definition for distance separation based on our current measurement techniques and places that in a definition section, and it has no other substantive changes. There is a First Amendment which corrects a portion under the animal keeping and husbandry section. It just clarifies that the secure enclosed or fenced area is from that fence to the residential dwelling, school, or individual care center, which is consistent with the current code.
Okay, thank you. I'll open us for public comment. Anyone from the public want to speak on this bill? I'll close public comment. Any comments from up here? You want to speak on this bill? All right, come on down.
I'm not sure if it's the same bill I'm here for, so I want to clarify that I'm here because of a...
Hold on. Come on down and state your name and go ahead and ask your question.
Hi, my name is Harry Lee Baptiste. I'm homeless. I used to run a nonprofit called People United for Justice. I no longer run People United for Justice because I just didn't have the money to continue.
So what bill are you here?
I'm here because of an ordinance in which I heard very little about concerning homeless people and concerning the issue of if you got caught sleeping on the sidewalk, you can wind up with $1,000.
Yeah, we're not hearing that bill today.
You're not hearing that bill today?
No, that bill will be introduced on Wednesday.
On Wednesday?
And then it won't be even heard on Wednesday, right? It won't be heard till the following meeting. So
Correct, Chair. The hearing, sir, will be on November 6th, next Wednesday, pardon me, about 3 Wednesdays from now.
3 Wednesdays from now?
Yeah.
That'll give me more time to get more research.
Yep.
Perfect.
Thank you all for at least hearing me.
Yeah, so
and may God continue to bless this council and this meeting. But
Thank
most
you.
of all, I'd like to say they did a wonderful job in building this. They did a wonderful job. I'm a builder. I built all my life, and I'm proud of the trade. May God continue to bless y'all. Peace.
Well, you're invited anytime, but put down November 6th.
I will. I'll be here.
And we'd be glad to have you come down and make comment then. Thank you, sir.
Is
Yes,
that
and-
before the bill passed or?
No, that's when we're going to hear the bill. But, sir, I have to just tell you, you're very articulate, and I'm happy that you're coming to be part of the process. And I was wondering if you have been down to our Corridor of Hope. I mean, since you're a builder and you've done profits, we have a lot to offer you down at the Corridor of Hope. And if you would go and Corridor of Hope, and Luann can give you the address, and we could probably help you get employed.
I'm very familiar with the courtyard because I am the person who demand that Formaster be cleaned up. I am considered the mayor of Formaster of Tent City. I am very active in this. I am the only homeless person who's an activist for homeless people, who sleeps with homeless people. So I know the needs of homeless people because I am one.
Fabulous. Well, I look forward to talking with you again, and I look forward to working with you together in the Corridor of Hope.
God bless you.
God bless you, too.
Thank you, Father. Thank you.
Anyone else want to speak? All right, I will close public comment. Any comments or motions up here?
Motion to approve, send to council.
With the First Amendment? Okay, I have a motion to approve with First Amendment. Go ahead and vote. Motion carries unanimously. This bill will be recommended to the November 6th, 2019 City Council meeting. Thank you. Item 4, Bill number 2019-34 for possible action amends the town-centered development standards manual to allow the waiver of certain minimum distance separation requirements in relation to the use of packaged liquor off-sale establishment, sponsored by Mayor Pro Tem Fiore. Mr. Lowenstein.
Thank you, Chairman. This bill seeks to allow a waivable provision of the distance separation between a packaged liquor and a similar use, as well as a tavern within the town center special area plan.
Okay, I'll go ahead and open this to the public. Any public comment on this bill? All right, don't see any, so I'll close public comment. Any comments or motions up here?
Motion to approve?
All right, we have a motion to approve. Go ahead and vote. And post. Motion carries. This bill will be recommended to the full City Council on November 6, 2019. Agenda item number 6, Bill 2019-35 for possible action, amends the LVMC Title 10, a new chapter to establish a city misdemeanor offense of battery, which constitutes domestic violence, along with corresponding penalties, sponsored by our city attorney, Brad Jerbick, who wants to introduce.
I can take it, Chair.
Okay.
Thank you, Chair. Jeff Dorkek, Deputy City Attorney, for the record. I'd just like to highlight the background and key provisions of this proposed ordinance before the committee opens up the public hearing. 1 month ago, the Nevada Supreme Court ruled in a widely publicized decision that an individual charged with state law, that is Nevada Revised Statutes misdemeanor of battery domestic violence, is entitled to a jury trial if so requested by the defendant. Our state Supreme Court reached this conclusion because the Nevada legislature in 2015 prohibited an individual from possessing any firearm if he or she is convicted of the misdemeanor crime of, quote, domestic violence, importantly with domestic violence defined by federal law. The Supreme Court's decision created both logistical and jurisdictional dilemmas for the city of Las Vegas and other incorporated cities in Nevada. Logistically, the city's municipal court presently has no jury administration, no ability to summon a juror pool, and even no jury boxes. Jurisdictionally, a plausible argument can be made that the city's charter and the charters of our sister cities do not permit the use of jury trials in municipal courts. So with these issues, the interest of domestic violence victims and the rights of criminal defendants in mind, the criminal and civil divisions of the Las Vegas City Attorney's Office crafted the legislative option before the committee this morning. Before I turn to the provisions of this proposed ordinance, it should also be noted that this bill is not unique to the city, and it does not use novel language. Indeed, very similar proposals are on the table in Henderson and North Las Vegas, and the provisions of this bill, the definitions, the penalties, the fees, and other requirements contained in it are taken directly from the state's battery domestic violence law. In all, this proposed ordinance will simply allow the city's prosecutors to charge individuals under the municipal code with the misdemeanor crime of, as the chair mentioned, quote, battery which constitutes domestic violence, while maintaining the same penalties and counseling options found in state law, but without triggering the jury requirement because a domestic violence charge based on a municipal ordinance does not meet the federal law's definition of, quote, domestic violence that I referenced earlier. So turning quickly to the specific provisions of this proposed ordinance. Section 10 of the newly proposed Chapter 10.32 defines battery which constitutes domestic violence. That is the new charge that the bill will create. Section 20 of the new chapter lays out the imprisonment and fine penalties, the requirements for counseling of convicted individuals, and the court's ability to require alcohol and drug treatment. And finally, we do have a minor word change, which will be an amendment. Page 1, line 11 of the bill should read Title 10 of the Municipal Code of the City of Las Vegas rather than Title 10, Chapter 32, Section 10. So that's just a writing correction as the First Amendment. With that, Chair, if the committee has any questions now or after public comment, we have two of our criminal division attorneys here to address your questions and respond to any comments. In addition, our senior assistant city attorney, Brian Scott, is also available.
So if I understand this correctly, just so I'm clear on this, we're creating a battery domestic violence statute or an ordinance that mirrors the state battery domestic violence. Everything else, everything's pretty much the same, except it doesn't trigger the confiscation or the taking of a weapon, which means you don't have have to have a jury trial. Is that pretty much it in a nutshell?
Yep, you might say I'm already, but yeah, beautiful summary.
Okay, okay. All right, so if a victim of battery domestic violence will have all the rights and availability of everything else within a state statute in this particular statute, is that correct?
That is correct, Councilman Anthony.
Okay.
Can you repeat your name, sir, for the
It's
record?
Martin Orsinelli. I'm Senior Deputy City Attorney, Criminal Division, City of Las Vegas.
Thank you.
Okay, okay, that
If I
helps.
can add, importantly, what it does is with this ordinance, we can get the enhancements back in, and we can get the mandatory counseling, the mandatory 2 days of jail, everything that the statute had that we're not able to do now. So if somebody were to commit a battery DV with our ordinance and they were out to get it, and they went out and got another one, the DA's office said that they would consider our ordinance in enhancing a case in the future if they were to get another one, if it went up to the felony level. So I think that's an important determination in order to protect victims.
Okay, because I know the most important thing is that the battery domestic violence laws and ordinance are basically in place to protect the victim, to provide for help for the victim and the person that committed domestic violence, to get them counseling and that sort of thing, so this stuff doesn't happen again.
That's
So
correct. We
this
try to-
ordinance does that.
Right, we try to provide education. Everything is geared to making sure the defendant doesn't do it again.
Okay.
And if they don't learn the second time, the penalties become harsher, the counseling becomes longer. If they don't learn, the next one's a felony. So everything's geared to teaching them not to do it again and to make sure it doesn't happen again. Unfortunately,
Great.
sometimes people don't learn, but at least we'll have that felony teeth for the future if we
Okay.
pass this ordinance.
Any questions up here until let's open up for public comment first? Okay, all right, thank you very much, good explanation. So let's go ahead and open it up for public comment. If you want to make a comment about this particular ordinance, please come on up, state your name, and make your comment. Again, just to be clear, if people don't understand the recommending process, we'll end up voting here whether to recommend this to the city council. And this bill will be forwarded to the city council for an October 16th, actually in 2 days, for a vote by the entire city council, just so everybody understands that process. So, welcome.
Thank you, Councilman. For the record, my name is William Horn, Vice President, Strategies 360. I'm here representing our client, SafeNest. SafeNest is the largest provider of victims of domestic violence, not only in our county, but in the state. And we're here to object to this ordinance. I will touch particularly on some of the legal issues that were mentioned here. As council, I'm also a licensed attorney in the state of Nevada. First, this ordinance does mirror state statute up until the part where it deletes the provisions on weapon confiscation for those convicted of battery domestic violence. We find this problematic for two reasons. One, legally, it's a circumvention of state statute. The state legislature found it important to put this provision in statute in 2015 for the protection of victims. And the SafeNest CEO, Liz Ortenberger, is here, is going to talk to you about the risk of victims of domestic violence when a firearm is present in the home. Simply removing it in your ordinance and saying that it's fine and we're going to keep all the other provisions is an illegal circumvention of state statute, and also it does not protect victims. Moreover, it doesn't protect law enforcement. Domestic violence calls, one of the most dangerous calls law enforcement has when they're going on those calls. And SafeNest has been spending a lot of time working with Metro on this very issue and working with Metro in providing services for victims of domestic violence. We believe that it would be more useful for this city council to reach out to the leaders of the state legislature and to the governor and ask for a special session in which they can fix these particular problems so you don't have to try to circumvent and not comply with the Supreme Court ruling. And that takes me to the other issue. I understand that all but Boulder City in Southern Nevada, in their charter, prohibits jury trials. But I'm of the opinion that since the Supreme Court has basically ruled that it is unconstitutional to charge somebody with battery domestic violence and not give them a jury trial if they want to, that provision in your charter is now unconstitutional. You can't say to the Supreme Court, we can't do a jury trial because it's in our charter that prohibits it. The Supreme Court is the supreme law of our land, and they have said you have to give a jury trial if that defendant so requested. And so these are the issues that are of concern to us. And the first time, if you pass this ordinance, the first time that you do, I believe that defense counsel is going to sue that it's an improper use of the ordinance, and we're going to come to a complete standstill, and we haven't gotten anything resolved. I'm more of a let's try to comply and fix it while still maintaining an atmosphere where we're protecting victims of domestic violence. And with that, I'll close. I'm happy to answer any questions, or I'll allow Liz Ortenberger to speak from SafeNest.
Thank you for your comment. Yeah, come on up, state your name. There you go.
There we go. Liz Ortenberger, CEO for SafeNest. So there's some important things to understand. The city of Las Vegas carries 55% of all misdemeanor cases for domestic violence for the state, 4,500 on average a year. If we move that back without the firearm provision, 500% higher chance of homicide in a victim's home if a gun is present. 500% higher chance in the state that is already second worst in the country for domestic violence homicides. Not only that, in 2017, more officers were killed on domestic violence calls in our country than any other type of call. So removing the firearm provision not only is unsafe for victims, it's unsafe for our officers, and the magnitude of cases that the city of Las Vegas deals with, we cannot support moving backwards. And taking away the firearm provision does that. I can't imagine a Metro officer responding to a call and checking their address book to see if that's a county or a city property because they want to know if they're at risk, particularly if it's a house where a convicted offender already lives. So we ask that you do not pass this ordinance. We'd rather see a delay. Let's get the stakeholders to the table. There's a tremendous amount of data in the Nevada Arrest and Protection Advocacy Project that was completed last March around specialty courts and around these issues and around firearms and temporary protection orders as well. Because what we have to understand is this is not a system that has been working well up until September 12th. We have lagged behind other states for decades in the way that we are dealing with domestic violence, and simply removing one portion of it to make it work logistically for the city is not the right move for victims, and our homicide rate, not only of our victims, but of our officers, will increase. Thank you.
Thank you. Who else would like to speak on this ordinance? Come on up. Good morning. Go ahead and state your name. It's on. The microphone's on. Just bring it down.
Teresa Crawford, volunteer for Moms Demand Action for Gun Sense in America, part of Everytown for Gun Safety. Following the representatives from SafeNest, completely agree with everything they said. asking you not to recommend this bill at this time. As was said, domestic violence and guns are a deadly combination, especially in Nevada. We range in the top 5 for women killed by men, more than half with a gun, year after year after year. We need to be working on taking firearms away from convicted abusers, not allow them to stay in the home. 46 other states have figured out how to provide the right to a jury trial to those convicted of similar crimes, and we think Nevada can figure it out too with stakeholder meetings and more legal analysis. Thank you.
Thank you. Anyone else?
Yes, my name is Wendy Starkweather, and I'm here as a local volunteer with Moms Demand Action for Gun Sense in America, which is part of the Everytown for Gun Safety organization. I'm here also to ask you to not recommend Bill 2019-35, which would add to Las Vegas Municipal Code Title 10 a new chapter to establish a city misdemeanor offense of battery, which constitutes domestic violence, along with corresponding penalties. I'm aware of the arguments in favor of making the change to the city code, as described earlier, in order to avoid jury trials, which the city cannot conduct. But this fix is a workaround that actually will further harm the survivors of domestic violence. We can't ignore the harm that will be caused by allowing people convicted of domestic violence to keep their weapons. This point was very well identified by Liz Ortenberger. I urge you to reject this bill and instead take that important step back, work with the county and state officials to find a solution that will prioritize the survivors of domestic abuse over government convenience. Thank you very much.
Thank you. Come on up. Anyone else?
My name is Sasha Brees, and I'm here as a member of Moms Demand Action for Gun Sense in America, part of Everytown for Gun Safety. I'm here to ask you to not recommend Bill 2019-35. Under both Nevada state and federal law, those convicted of misdemeanor crimes of domestic violence are prohibited from possessing and purchasing guns. Our city must identify solutions that prioritize public safety rather than suggesting workarounds to the problem. Here in Nevada, we experienced the deadliest mass shooting in our nation's history in October 1st, 2017. What most people don't realize is that statistically, domestic and family violence is a driving factor in most mass shootings. An Everytown analysis of mass shootings revealed that at least 54% of those incidents, the perpetrator shot a current or former intimate partner or family member. We must protect victims and survivors of abuse by keeping guns out of the hands of domestic abusers, and in turn will help stop future mass shootings. Thank you.
Thank you. Anyone else?
Councilman Martin Orsinelli for the City of Las Vegas again. Addressing the question about whether or not it's legal to have this ordinance, we have researched it, and we know we're going to have to defend the ordinance. There's no doubt about it. But we also believe by our research that we will be able to defend the ordinance. We believe it is legal. The other thing, we're all on the same page. We don't want defendants to have guns. We get it. But don't forget, you don't get there unless you get a conviction for domestic violence. Right now in the city of Las Vegas, we do not have a domestic violence law, basically. Ever since this case came out, we've been charging what's known as simple batteries. They're just regular batteries. We don't charge a domestic violence battery because the court does not have the ability to do a jury trial at this time. It's going to take months, if not longer. We also do believe that there's a law against it. So instead of trying to fight it, we're trying to work with it so we can protect victims. We've talked to the DA's office, we've talked to the other jurisdictions, we've had meetings. This will allow us to hold defendants accountable until the legislature does something. We don't know when the legislature is going to do anything. It might be 2 years. That's a lot of victims that will be going without a court date, without their day in court. We, as the city attorney's office, can't deal with that. We need to work now. There's 3 choices. One is to go the way we are, where there's no domestic violence law. Defendants, basically, they can be convicted of simple battery. There's no enhancement. We can request that they be sentenced to the DV sentence requirements, but it's up to the court. They don't have to follow it. The second thing that we can do is pass the ordinance, which we're requesting because we want to protect victims just like these fine folks do. At least we'll have something until the legislature meets. I will also tell you, there was a seminar on Thursday. There was 2 legislatures there, and one was Ozzie Fumo from the Assembly. The other was the chief of the Judicial Committee. I don't remember his name. And also there was a person from the DA's office in charge of their lobbying, and there was the chief of criminal from Henderson. And what they said is the legislature doesn't want to do a special session at this time because they can't agree on what to do. They don't know what to do. One of the suggestions was to make all these a gross misdemeanor, which would be an even more serious charge. The DA said they don't like that because they can't handle the extra cases. So that's where we're at. There is no special session schedule. If they get one and when they can do something, then that's fine. But until then, I just hate to see us sit on our hands and do nothing. Now, the third thing that some people have suggested is sending these to the DAs. We've been in meetings with the DA. They can't handle what they have. They're scheduling 20 trials, 12 trials in 2 or 3 weeks. They have a backlog of cases. These cases, you're not going to get domestic violence convictions because there's just too many cases right now. They can't handle it. If we send them our cases, they're going to have even less convictions. So what we're requesting, we know it's a tourniquet. We know that we're trying to stop the victims bleeding, but it's what we got, and that's why we're suggesting it. But it's not an easy choice. We understand what these people are saying. We agree with them. But we're between a rock and a hard place, and this is what we suggest that happens.
Thank you. Anybody else from the public want to make a comment? Okay, I'll close public comment, and there's probably a couple of questions up here. So, Jeff, I have one. This ruling is effective immediately, right?
Correct. It came out a month ago, and it's binding from the time it comes out.
So if if you wanted to prosecute somebody for battery domestic violence today, they could demand a jury trial, is that right?
Right. This criminal division's had this issue. If they've attempted to demand it, obviously that's when we would lower it to simple battery because we just can't do a jury trial.
Okay.
Infrastructurally, we just can't do it.
Okay, so that's what would happen. They would demand a jury trial.
That's what happened, and they did because, any good defense attorney is going to know we can't do jury trials. So they demanded a jury trial. Some got actually set, but then we discovered the law that says we can't do it, and we felt like that was a pretty big hurdle. Also, the fact that we couldn't get a jury put together in time. So what we've been doing is charging what's known as simple batteries because the court cannot do jury trials right now, and we don't think we legally can either. So ever since that case has come out, we have just been doing simple batteries. We don't like it, but that's what we've been doing.
So it's kind of weird putting it this way, but the defendant then wins, right?
It's not good. I mean,
they're getting found guilty for just regular battery instead of battery domestic violence.
Yes.
They know that, so their smart attorneys are going to ask for a jury trial knowing it's going to be dropped, whereas this ordinance would at least allow us to elevate it back up to battery domestic violence with the provisions in the state, obviously without the firearm.
Correct.
Right.
Correct.
And I'm assuming in the meantime, if this does pass, that everybody's getting together to try to come up with a different solution in the future to bring the firearms provision back. I'm assuming people are still going to be talking about that.
Yeah, we're having a lot of meetings. I mean, I've been involved in a lot of meetings where there's a lot of discussions. Special session's been discussed, but from what I understand, right now, they're not ready, because there's not an agreement on how to address it.
Okay.
So hopefully that answers your
Yep, that's
question.
good.
Okay.
So, are there other questions up there? Councilman Knutson?
Yeah, more of a comment. So, Mr. Orsinelli and Ms. Ortenberger and Mr. Scott met in my office last week, trying to identify if there's opportunity for consensus around how the city should proceed. I don't feel comfortable making this decision. I think there are longer-term implications for the decision that we make today. And I would like the opportunity to ask for maybe a 30-day abeyance on this particular item so that I have more opportunity to learn what the implications of this decision are. I'd also like, for the same folks that I met in my office that I just mentioned, if we can brainstorm what a longer-term strategy would look like. So if we're adopting this particular ordinance in the future, we understand what our obligations are to work with the county or the state on changing laws that'll be beneficial for both the city of Las Vegas and the victims that we serve. So my thought right now is I don't have enough information to make this decision, and I would like to ask for another 30 days to work with the folks that I mentioned before.
Councilwoman, Mayor Pro Tem Fiore.
Thank you. So I have to tell you, I'm very familiar with the history of this piece of legislation. I've also served 4 special sessions, and it's not easy to get a special session on. And Mr. Horn, former Assemblyman Horn, and I both worked on this in 2015 together up at the session and voted for it. Because of the time crunch, and I wish my colleague would, talk to me on this. One of the things that I'm a real stickler about is facts, right? Facts. So when we're talking about a city ordinance that applies to the city, and you guys come up here, not you, come up here and give me national numbers, the 500% of this, and that does not work for me. When you come up here and represent every town, that does not work for me, because the numbers are skewed, and it's national, and it does not belong in the city of Las Vegas. So because of Mr. Knutson's request, what I would request is to make a motion to move it to council without a, just move it to council without a recommendation, so all of the council members can weigh this out, and we can discuss this in briefing tomorrow. I don't know how you feel about that, Chair. And it's just a time crunch issue right now because of the Supreme Court ruling, and it's effective now, today, and that's what I'm concerned with. And the other thing I'm concerned with is, as people represent this domestic violence battery charge, when it goes to simple battery, they get off and they get to keep their guns. And that's not okay. That's not okay. So if we don't put this to the council this Wednesday, all these folks get to keep their guns. We are literally preventing them because we're stepping it up to a domestic violence. So I would prefer, if you actually understood that you were in support of this bill. I'm not going to recommend this with support. I'm going to recommend it without recommending to the council, so the council can then concur with it.
Okay, well, I'll tell you, I am absolutely in favor of this ordinance. If we delay it, then those are 30 to 45 days of people that are going to be prosecuted for simple battery instead of battery domestic violence. And if the 4,500 number was thrown out, I don't know, divide that by 30, it's got to be 20 or 50, and I don't want them slipping through the cracks. So sorry, I'm not in favor of obeying it. I actually want to send it to the city council meeting on the 16th. I'm in favor of the ordinance, but if the motion is to send it without a recommendation by the recommending committee, I'm fine with that motion too. But I don't think we need to delay it. I think we need to take action and start moving forward.
Yeah, and take action to get the firearms out of real criminals' hands. So understand that we are with you, and I think your understanding of this bill is not clear on your end. So I'm going to go with
I just want to see if Councilman.
I just had one more question for Mr. Orsinelli. What's the average time between arrest and seeing a judge now?
It all depends. Some people see judges, if they remain in custody, within a couple days. Some are probably about 3 weeks out for initial arraignment, depending on if it was an arrest. We also get submissions where defendants are gone. Those take a little bit longer to come before us. But there could be 2 to 8 defendants a day that are in custody that see a judge within 72 hours.
Specifically for domestic violence?
Yes, yes. There's probably, there's probably 100 a day that are in custody for different things, and I think I'm being conservative saying 2 to 5 a day that are that are arrested for domestic violence, but we can't charge domestic violence when it comes time to charge.
Thank you.
So there would be some that either get let out of custody or that would plead to a simple battery.
Okay, any other questions?
No, we just have 2 motions on the floor, so if you want to take them in order of time, Councilman
Actually,
Knutson.
we don't have a motion yet.
Oh, no one.
Nobody's made a motion, so hold on there, Jeff. Okay, is there a motion?
Yes, I'm going to make a motion to send it to council without recommendation. This way, everyone can be clear, and the council can rule on it together as a whole.
And that'll be for the April 16th city council meeting?
Not April.
April, why would I say April? October 16th city council meeting, so go ahead and vote. 2 people didn't vote,
You didn't vote.
and Brian didn't vote either.
Do you want to just do ayes?
Yeah, I'll say yes. Aye, okay, so motion carries unanimously. This will be sent to the October 16th city council meeting. That's Wednesday. I don't know what'll happen that day. It's up to the mayor whether she will allow further public comment at that city council meeting, and we'll do something on that date. But it goes to I recommend it, but it's going to the city council without a recommendation by this body, so just so everybody understands that.
Yeah, and I just want to really make it clear that this ordinance takes guns out of the hands of, I want to make it clear that this ordinance takes the guns out of the hand of folks, because if we don't, it goes to a simple battery, they walk with their guns. So this is in need to help us with the legislation that Mr. Horn and I passed in 2015.
Do you want to clarify?
Yeah, just to add on to Mayor Pro Tem's comment, if you go to simple battery, obviously there's no gun issue involved, so if the person had a gun, he would keep the gun. Under our city ordinance, though, the gun would be kept as well because it is a city misdemeanor ordinance rather than what's described in the federal law, which is used in the state law. It's kind of complicated, but not that complicated. So long story short is you would keep the gun under simple battery or the proposed ordinance.
Thank you. Okay, we will now move on to bill number 2019-37 for possible action. Creates the City of Las Vegas, Nevada Tourism Improvement District Area 15, located within the area bounded by Desert Inn Road to the south, Rancho Drive to the east, and Sirius Avenue to the north. This is sponsored by Councilman Knutson. So, good morning.
Good morning, Chairman Anthony, Mayor Pro Tem Fiore, Councilman Knutson. For the record, Jason Thompson, City of Las Vegas, Deputy Director of Economic and Urban Development. Also here, appearing on behalf of the developer is Jennifer Lazovich from Kemper Kroll. This bill creates a tourism improvement district for Area 15, which is a new, unique retail experience-based project. It's being developed by Fisher Brothers, who's a real estate development company out of New York. It'll be built on approximately 15 acres and will contain 126,000 square feet of leasable area that will include a curated artistic interactive common area known as Meow Wolf, indoor and outdoor event space, a food cart and retail kiosk opportunities, as well as on-site commercial-grade kitchen commissary and roughly 800 free parking spaces. It'll be a 20-year TID, will be capped at the lesser of 3.13% of the gross sales tax revenue, or $688,000 annually. The TID will just include phase 1 of the project. And with that, I'll close my comments and see if you have any questions.
Okay, I'll open up for public comment. Anyone from the public want to say anything? All right, I will close public comment. Anyone up here would like, I guess I should turn my microphone on. Let's try that again. Anyone from the public want to say anything on this ordinance? All right, I'll close public comment. Anyone up here would like to say anything? Mayor Pro Tem?
So I'm jealous because it's in Knutson's ward, and I love this place, I just have to tell you. And so, of course, whatever my colleague wants to do, I'm going to do. But I just have to give kudos to this particular project. And why I have to give kudos to this particular project is because once upon a time, I was involved in 2014 with a lot of folks coming around the globe and the United States for an event in Bunkerville, Nevada. Well, when some folks, wanted to have a party near our military Area 51, your project, these folks stepped up and diverted a lot of that attention and got them to go down to Area 15 in kind of like a marketing thing. And I just see a great community partnership here developing with Area 15 and our city. And I'm really just hoping, Councilman Knutson, that, as we go forth, there's a couple of folks that are involved with 15, that we are a real proponent of theirs and help them with all their stuff.
Thank you.
Yeah, thank you very much, Mayor Pro Tem. I agree. It's one of the most exciting projects I've seen in the city in a long time, and we've been working a lot with Area 15 and Meow Wolf, which is the anchor tenant at Area 15. I think there's going to be many, many things that come before the City Council that have to do with the infrastructure and the city's engagement with Area 15. So I'm excited about the project, and with that, I'll motion for approval.
All right, I have a motion to approve. Go ahead and vote. And post. Motion carries unanimously. That will be heard at the October 16th, 2019 City Council meeting.
Thank you.
Next agenda item is item number 7. Thank you. Bill number 2019-38 for possible action, annexation, property location at the southeast corner of Lake Mead and Fairhaven, petitioned by Suerte Sete LLC, acreage .63 acres, zoned RE, sponsored by Councilman Creer.
Thank you,
Mr.
Mr.
Lowenstein.
Thank you, Mr. Chairman. Everything is in order.
Okay. I'll open up for public comment. Anyone from the public want to speak on this bill? Seeing none, I will close public comment. Anyone up here?
I just motion for approval.
I have a motion to approve. Go ahead and vote. Post, motion carries unanimously. This bill will be heard by the City Council on November 6th, 2019. Item number 8 is citizen participation. Anyone from the public want to speak about anything? Come on up to the microphone. I don't see anybody, so I'll close citizen participation. And item number 9, we are adjourned. Thank you very much. Thanks, everyone. We'll see you later.